This week's top story is how New Jersey is sticking their nose where it doesn't belong and attempting to prevent ATF from returning people's confiscated property. This is after a federal court in Texas entered a permanent injunction against the agency and ordered the stuff returned. Unsurprisingly, New Jersey and 15 other states are attempting to insert themselves as a party in a case where they were repeatedly told they're not welcome. For more context, last week, New Jersey filed a letter with the Fifth Circuit to notify the court that ATF had begun to return force reset triggers, or FRTs, that it unlawfully confiscated from people based on its interpretation that they were machine guns. Now, a little more information is needed before we get back to the latest development. In July of 2021, ATF's Firearms Technology Criminal Branch, also called the Tech Branch, issued a report in which it classified the FRT-15 as a machine gun. In October of that year, the Tech Branch found that the Wide Open Enterprises, or WOT version, was also a machine gun. Finally, in March of 2022, ATF issued an open letter stating that the ATF recently examined devices commonly known as force reset triggers and has determined that some of these are firearms and machine guns as defined by the NFA and GCA, which resulted in the confiscation of said FRTs. So that's how we got here, sorta. And what happens when ATF does stupid things? Well, they get sued.
We're gonna sue you!
We are gonna sue you!
NAGR and several others filed suit against the agency in the Northern District of Texas, claiming that ATF's interpretation and enforcement was arbitrary, capricious, and otherwise contrary to the law, and asked the court to permanently enjoin ATF from enforcing its interpretation and to return all of the confiscated FRTs. I'm going to spare you guys the details, but the court did just that, that being the enjoining and returning thing. And after some requests for more time to identify who the confiscated FRTs belonged to, which the court gave ATF, ATF ran up against the wall to start returning them. Yeah, apparently organizing confiscated property was a little difficult for the agency, but anyway. In between all that time, the government appealed the decision, which has now been argued and is awaiting an opinion from the Fifth Circuit, which brings us back to New Jersey. Back in January, New Jersey and its Federation of States filed a motion to intervene in this case. Why? Because it said the federal defendants can no longer be counted on to defend the classification on the merit, meaning they don't think the feds will continue to argue that FRTs are machine guns because there was recently an election which ended with
America is back.
And as you may have guessed, their motion denied. Apparently, not one to read the tea leaves, the states filed a motion for reconsideration, which was also denied. So the states here were forced to participate how most groups are at the appellate level, by filing an amicus or friend of the court brief. In addition to notifying the court about the return of the FRTs, which it kind of already knew because it was on the order, New Jersey complained that the return of these weapons presents a significant and irreparable danger to public safety and underscores the need for a prompt ruling from this court, being the Fifth Circuit, reversing the district court's final judgment and order. It went on to continue arguing its position, which nobody cares about. NAGR promptly filed a response pointing out that New Jersey had no right to file such a letter or attempt to expand the appellate record as it wasn't a party. It also requested that the court, quote, disregard amici state's notification letter, end quote. Don't need the end quote, but I'm gonna say it anyway because why not? By all accounts, it's likely the Fifth Circuit's not going to pay any mind to New Jersey's letter, given it denied their motion to intervene and denied their request to reconsider that denial.
End quote.
End quote. In the meantime, ATF has begun to notify individuals about the court order requiring them to return their property. In other words, we stole your stuff, we shouldn't have stolen your stuff, but now you can have it back because the court said so. We're going to see how this one plays out, but given the Fifth Circuit's prior opinions on gun-related matters like bump stocks, well, I'll let you be the judge.
End quote.
Welcome back to the Big 2A, the show where we bring you all the top 2A stories. I'm your host, Adam Kraut. I'm going to be back at GunCon for 2025. Come see me and the other band of merry hooligans at GunCon this year in Cleveland, Ohio on June 28th. Head on over to guncon.net to learn more. Would love to see you there. GunCon. Sticking with the courts, last week the Supreme Court heard oral argument in Smith & Wesson versus Mexico. For those of you that haven't heard about this one, Mexico, with the help of some very anti-Second Amendment lawyers, sued a variety of gun manufacturers, including Beretta, Glock, Ruger, Colt, Barrett, and obviously Smith & Wesson. The trial court dismissed the lawsuit, but that decision was appealed, which resulted in the First Circuit overturning that ruling. Of course, this lawsuit implicates the Protection of Lawful Commerce in Arms Act, or PLACA, which we covered on the legal brief. If you want a deeper dive, check that episode out to learn more. Remember, PLACA is extremely important because it's the shield that protects the industry from bullshit lawsuits designed to bankrupt manufacturers. The questions before the court: 1. Whether the production and sale of firearms in the United States is the proximate cause of alleged injuries to the Mexican government stemming from violence committed by drug cartels in Mexico. And 2, whether the production and sale of firearms in the United States amounts to aiding and abetting illegal firearms trafficking because firearms companies allegedly know that some of their products are unlawfully trafficked. So, simple version, they're blaming US gun manufacturers for cartels being murderous assholes. How, you might ask? By aiding and abetting the violation of federal laws. And under federal law, an aider and abetter is liable for harms that were a foreseeable risk of that violation. So, as Mexico's lawyer put it,
the laws broken here are designed to keep guns out of criminals' hands. Those violations put guns in criminals' hands, and those criminals harmed Mexico.
While the justices asked a multitude of questions about aiding and abetting and PLACA itself, a few points were made that makes Mexico's theory less likely to succeed. First, PLACA was designed to shield manufacturers from this type of harassment litigation unless someone suing can demonstrate they meet one of the 6 exceptions in the statute that allows a lawsuit to continue. One of those exceptions requires a knowing violation of the law. And not just any law, but a knowing violation of a federal or state law applicable to the sale or marketing of the product, and that violation was the proximate cause of the harm for which relief is sought. The exception specifically states that it includes, and bear with me because this is legal language, any case in which the manufacturer or seller aided, abetted, or conspired with any other person to sell a qualified product, knowing or having reasonable cause to believe that the actual buyer of the qualified product was prohibited from possessing or receiving a firearm or ammunition. So put simply, a manufacturer knew that the guns were going to prohibited people when they sold them. Newsflash, that's not how the gun industry works. As the lawyer for the manufacturer said, they don't sell directly to dealers, meaning there's third parties between the manufacturers and the dealers, which cause the issues with Mexico's theory. I'll leave you with this parting thought from the manufacturer's lawyer.
At the end of the day, PLACA is about protecting Second Amendment rights. It's not just about protecting the manufacturers, the distributors, and the retailers, but it's protecting the right of every American to exercise their right under the Second Amendment to possess and bear firearms. That right is meaningless if there are no manufacturers, retailers, and distributors that provide them in the first place.
It wasn't us, mother.
Woo! At least one congressperson seems to understand the important issue relating to Second Amendment rights. Representative Thomas Massey introduced the Second Amendment for Every Registrable Voter Act, or Safer Voter Act. How clever. While I may not be a big fan of the bill's name, I am a big fan of its contents. As the name implies, it would reduce the minimum age at which a person may obtain a handgun from an FFL down to 18 instead of 21. And the best part? The bill's really only 1 page long once you remove the header from it. This issue is somewhat near and dear as SAF is currently litigating a variety of 18 to 20 challenges across the country, including 2 that challenge the very federal ban that this bill seeks to remove. Of course, age-based bans are having a rough go in the courts with a number of decisions finding 18 to 20-year-olds are part of the people and have full Second Amendment rights when they turn 18, which is how it should be. While I think this bill would be a fantastic win for gun rights, with the way the Senate's comprised and a potentially bumpy road in the House, I don't give it much hope of making it to the president's desk. So hopefully the Supreme Court's going to take any number of these 18 to 20 challenges headed its way and put this issue to bed, removing the need for any legislative action and preventing legislators from across the country from being able to implement age-based bans. But that's not all that's happening in Congress. Recently, Representative Mike Bost, the chairman of the House Committee on Veterans Affairs, introduced H.R. 1041, also known as the Veterans Second Amendment Protection Act. The bill seeks to reduce reporting of veterans to NICS as prohibited persons when someone else steps in to manage their money. This was an issue during Trump's first term with the Social Security Administration, which had basically implemented the same kind of rule during Obama's last term and would report those people to NICS as well. In 2017, Congress passed Senate Joint Resolution 14, which repealed the rule requiring the Social Security Administration to report those people to NICS. So how does the bill address the issue with the VA? It would prohibit the VA from reporting veterans to NICS who have someone else managing their money, unless there is an order or finding of a judge, magistrate, or other judicial authority of competent jurisdiction that such beneficiary is a danger to themselves or others. It seems at least a few members of Congress understood what the Supreme Court's decision in Rahimi stood for. Whether this bill will run the gauntlet to wind up on President Trump's desk remains to be seen, but tackling these issues head on is something our representatives need to do, and that's good news for gun rights.